addressing the defendant, please state your name.
Brian Lee Drips.
Have you been advised of your rights by watching the video?
Yes, sir.
Or do you feel that you understood what you saw and heard?
What's that, sir? Oh,
Do you feel that you understood what you saw and heard of your rights on the video?
yes, sir.
All right. The gentleman to your left, if you would state your name, please.
Your Honor, I'm Josh Taylor. I'm counsel for the defendant.
All right.
For Mr. Drips.
And you have been privately retained.
I have, as of this moment, will address indigency. Probably, he hasn't had a chance to fill out the form, but that's probably something I should know for the court's record is on the horizon.
I note that the Bonneville County Prosecutor, Danny Clark, is present. I see in the Registry of Actions, Mr. Clark, there was an original complaint, and I see a motion to amend the complaint with a proposed amended complaint.
That is correct, Your Honor. Would you like me to address that?
Yes.
Just so the court's aware, we originally filed the complaint about 11 p.m. last Thursday night, so that was done without the aid of the Odyssey system. Also, you'll notice a couple of changes in that. We now we got the defendant's full name. That was part of the amendment. The other part of the amendment was to charge the statute correctly as it existed in 1996. We charge the statute as it exists now, so that changes the subsection of the rape statute. Those are the substantive changes that were made on the amended complaint.
Mr. Taylor, have you seen the proposed amended complaint?
Your Honor, I have seen
I didn't hear. You have seen
it.
it?
Your Honor, yes, I have. I have it here in front of me.
So, Mr. Drips, you have now seen the amended complaint?
I have seen it now that I'm reading it right here, sir.
Okay. Do you need a few minutes to read that?
No, sir, I understand it.
Very well. Is there any objection to the motion to amend?
Your Honor, I will submit to the court. I know that under Idaho Rule of Criminal Procedure 7E, the state has a right to amend up until the time the prosecution rests. So I'll submit to the court.
All right then, I will accept the proposed amendment and grant the motion. There has been a proposed order. I make a verbal granting of that order at this time, and I will sign it after we're finished here. The defendant and counsel have indicated that they have received the amended complaint and that they have had a chance to read that. Would you like me to read it to you, or is that needed?
We don't need that, sir.
So you waive the reading of the complaint?
Correct, sir.
All right. These are felony charges, and on felony charges, I as a magistrate, I'm not authorized to receive any plea, whether not guilty or guilty. That will come in the district court should the case proceed that far. And so the next step here is the setting or scheduling of a preliminary hearing. Now, in these kinds of cases, there may need to be some additional time for either discovery or other preparation.
I'd like to. Sorry, Your Honor.
That's fine. So the general rule in any felony case where the defendant is in custody is that the preliminary hearing should be set and held within 14 days of the first appearance. That can be extended upon waiver of the strict time limit and on the request of counsel. So, as I repeat, and I'm sure the state may have some thoughts on this as well, is it your desire that a preliminary hearing be set within the general rule of 14 days from today?
No, Your Honor, we're gonna ask that it be set out. We've discussed with the prosecution a potential date. My client is prepared to enter a waiver to having that hearing held within 14 days.
Mr. Clark.
That is correct, Your Honor. Mr. Taylor's been in communication with our office. We appreciate that. Understanding what I presume the court's question would be. I believe Mr. Taylor has a couple of proposed dates. We may have settled on one that we would suggest to the court, but of course we'll defer to the court on the timing.
What date would you suggest?
Your Honor, we were looking at August 2nd of this year.
Your Honor, I believe that setting is on a Friday. My suggestion would be to schedule it for that date, schedule it for 9 o'clock in the morning, and whether this court or another court can handle it, I would think we could work that out. But just trying to get everybody on the same page, sometimes difficult.
Do you anticipate, if you know at this time, whether or not the preliminary hearing will need more than one day?
I believe it could be concluded in one day.
All right. I'll just ask my clerk, is there any reason you know why we can't set this for August 2nd? We'll go with August 2nd at 9 a.m. and we'll get formal notice out.
Your Honor, did the court note the waiver of time?
And counsel alluded to a potential waiver of time. Mr. Dripps, you understand that you have the right to have a preliminary hearing within 14 days from today, but because of preparation, et cetera, and as your counsel has indicated a preference, do you waive that time period, extend it out?
Yes, I do.
So the record will note the waiver of time. There is one other matter that I want to be clear on the record. Looking at the original and now the amended complaint, as far as count 1 goes and maximum potential penalties, it is listed as a death case, which then brings into play certain required procedures, which we don't need to go into at this point, but I want that on the record. Any question about that from the defendant or counsel?
Your Honor, my understanding is that the state has not yet, or will not until after the guilty plea, file a notice of intent as to whether or not they will seek the death penalty. I've discussed that with my client. I've also discussed that in this case, when the charge is murder 1, that death is a possibility in the state of Idaho.
Very well. And it's listed as a potential maximum penalty after count 1. Mr. Clark.
Well, let's just make sure we're clear. The state's obligated to file the notice within 60 days of the arraignment in district court. That's what counsel is alluding to. Those decisions have not been made at this point. However, the parties are proceeding as if it's a potential, so if those procedural things the court was referring to are being followed at this point.
Very well. All right. You've been advised of your rights, the charges, the wording of the complaint. You have counsel. We've set a preliminary hearing date. Is there anything else from the defense?
Your Honor, I have 2 more issues I would like to address with the court. One, first is just the issue of indigency. He has been privately retained, but he is indigent. His monthly income, he's on disability. So it's a little bit around $1,400 a month. I think he would qualify. That would, since we're following the procedures the court just outlined, that would come into play and be critical. I'm in contact with the Idaho Public Defense Commission regarding that. And so if at a later date, I'll need to bring that up. I just wanted to note it for the record. So that's the first thing. The second thing is that I would like to argue the issue of bail.
All right, let's take up the indigency matter first. And as you had indicated, Mr. Taylor, your client, if I heard correctly, hadn't filled out the application for public defender.
He has not. He was privately retained, on privately retained counsel. So here at the jail, The form would, I mean, obviously they wouldn't give him the form if I'm privately retained, but he does qualify. We have obtained the form, and so I anticipate if the court wants to go over his indigency right now on the record, or we can fill out the form and submit it.
Is there any objection, Mr. Taylor, to placing the defendant under oath regarding his finances for purposes of determining indigency?
Your Honor, I would have no objection to that.
All right, I'll ask my clerk to administer the oath. If you'd raise your right hand, please.
Do you solemnly swear that the testimony you're about to give in this pending cause should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. All right, you are Brian Lee Drips Sr.,
Correct, sir.
and your attorney indicated that your income is about $1,400 per month.
Correct, sir.
Is that take-home pay or is that gross?
That's gross.
Okay. Do you own any property, real property, land, or house free and clear of any mortgage?
No, sir.
Do you own any vehicles or other property free and clear of any loan or security?
No, sir.
So it's your testimony, or do you have any savings?
No, sir.
So it's your testimony that you believe you cannot afford to pay for an attorney?
Yes, sir.
Anything from Mr. Clark?
No, Your Honor.
Anything to add, Mr. Taylor?
Just that I'm privately retained, but it's by funds from separate party.
Understood. All right. Based upon the defendant's testimony regarding his ability to pay for an attorney, I find that he is indigent and would qualify for the public defender. I make that appointment. That then brings into play Idaho Criminal Rule 44.3, where there are certain qualifications that an appointed attorney, lead counsel, and co-counsel must comply with. If they have not, as of this date, they have 30 days in which to do so. Any questions or comments about that, Mr. Taylor?
No, Your Honor.
Very well. The next issue is bail. Judge Boyce
Yeah.
had made a finding of no bail on the original complaint. You may be heard.
Your Honor, I've had over a dozen people reach out to me over the weekend, which is unusual for the short amount of time I've been retained. I've had fathers and mothers, uncles and aunts, construction workers, ranchers, store managers, and I know what the complaint says, and I know the person that it described from 23 years ago, but that man is not this man. This man is described by those people as gentle and kind, a loving father, a good father. And so he has a place to live. He lives in Caldwell. He has the support of his family. His mother and sister have made the drive here today to support him. They're there in the courtroom. And normally, given his criminal history, which is just a misdemeanor, his most recent is 17 years old, I would be asking this court to release him on his own recognizance pursuant to pretrial release conditions. I understand that that's not probably where the court's going today, given the charges. But I would ask the court to consider a bond. I'll submit to the discretion of the court, but I would suggest a bond of $100,000.
I didn't hear you. I'm sorry. The number.
I would submit to the discretion of the court, but I would suggest a bond of $100,000.
Thank you. Response.
Thank you, Your Honor. We're going to oppose the request for any bail being set today. We're going to request that the court keep it as a no bail charge. Right now, the defendant's charged with a first-degree murder and perpetration of rape and with a forcible rape. As the court has already noted, that carries with it the potential of death penalty. The court's no doubt familiar with this case, at least in some tangential way, and the facts of the case are horrific. At this point, the state would point to a couple of different things. One, we recognize the defendant's record's minimal, but as is always the case with these types of crimes, the criminal record just isn't a factor really with the court's consideration. If this were a different type of charge, that would make more sense. But with this charge, those things just take a back seat to what we're dealing with here. What we have here is a DNA match from this defendant at the crime scene, all over the victim, all over the apartment, and we've got a confession that matches that statement. And so from the state's perspective, the likelihood of conviction is quite high. The likelihood of a significant consequence to this defendant is also quite high, as well as the potential for the death penalty. Based upon those things and where we're at right now, I understand some of those dynamics could change over time. And those could likely change, or perhaps change, in the district court. But as we're sitting here with an initial appearance, with these charges, with these facts, and this evidence, we're going to oppose the request for any bail being set today.
Thank you, Mr. Taylor. Anything else?
I understand that the state's opposed to it. I do note that the rules allow for it, even under the current circumstances where death is a possibility. And I will submit to the court.
Because of the gravity of the charges and the potential death penalty, I'm going to deny bail at this time. The Idaho Constitution and Idaho statutes allow, as the one exception, there may be one other or two, but there is an exception for bail, and therefore I deny bail. I stand on that, no bail order of Judge Boyce, and we'll go from there. Is there anything else, Mr. Taylor?
No, Your Honor, I have nothing further. If I could just have a moment.
You may.
Okay. That's it, Your Honor.
Mr. Clark, anything else?
No, Your Honor, thank you for your courtesy.
That concludes our arraignment.